The marble pillars of the federal courthouse rose like solemn guardians above the crowded hearing chamber, lending the environment a sense of ceremony tinged with quiet intimidation. At the bench, Judge Richard Lane adjusted his spectacles and reviewed the documents before him, readying himself to preside over what had swiftly become one of the most closely watched legal confrontations of the year. Representative Jasmine Crockett stepped toward the lectern with measured, composed assurance. Before her stood an army of elite corporate lawyers representing Tech Giant Corporation, one of the planet's most influential technology conglomerates, now accused of systematically harvesting and selling the personal data of millions of Americans without their meaningful consent or understanding. Every seat in the courtroom was occupied. Law students, reporters, activists, and ordinary citizens filled the room to capacity, some pressed against the paneled walls due to lack of space. Discreetly placed cameras recorded each movement and exchange. The air itself seemed to tighten, full of expectation. Crockett began her opening remarks. But scarcely a sentence passed before Judge Leon interjected firmly, his voice steady but unyielding. "Congresswoman Crockett," he began, tone sharp and authoritative. "Your position runs counter to established precedent in at least 3 federal circuits. Are you intending to ask this court to disregard decades of settled jurisprudence?" A wave of silence washed through the room. The clerk seated to the side traded anxious looks. The attorneys for Tech Giant exchanged knowing smiles, anticipating that the formidable judge would swiftly dismantle Crockett's reasoning. Yet what occurred next defied their expectations. Crockett paused. She breathed in slowly, and with a level voice shaped by intense preparation, she delivered a reply so exacting in legal reasoning, so elegantly constructed, that veteran observers would later describe it as an exhibition of advocacy under genuine pressure. At 81, Judge Richard Lane was a towering presence in American law. Appointed in 2002 by President George W. Bush, he had overseen decades of complex and nationally significant litigation. His decisions influenced both privacy doctrine and national security frameworks, and reshaped corporate compliance practices. Before ascending to the bench, Leon had held senior posts as prosecutor and defense attorney alike, including service as Deputy Assistant Attorney General and Special Counsel to congressional committees investigating major government corruption and intelligence controversies. His experience permitted him to examine disputes from competing vantage points simultaneously. He was renowned for exhaustive case preparation, and his questioning routinely revealed a deeper grasp of the arguments than the lawyers presenting them. His courtroom demanded intellectual rigor but upheld fairness with consistency. Facing him was Representative Jasmine Crockett, 45, of Texas's 30th Congressional District. Though only in her 3rd term in Congress, she had already gained a reputation as one of the most incisive legal minds in the Capitol. Unlike most lawmakers, she still practiced law selectively, stepping into litigation only when the stakes aligned with her commitments to civil rights and constitutional protection. Before entering public office, she had built a career as a civil rights litigator and public defender, educated at Rhodes College and the University of Houston Law Center. She had argued cases before state supreme courts and in federal appellate panels, specializing in matters involving constitutional privacy safeguards and government limits. Her dual life as attorney and legislator granted her rare authority. She understood how written statutes shaped human experience in everyday life, and in the courtroom she carried an intimate awareness of why those statutes existed at all. The present confrontation pitted her against Tech Giant Corporation, accused of extracting intimate personal data from millions of individuals and selling or transferring that data without informed permission. The company had already paid a nominal fine to the Federal Trade Commission, a penalty critics decried as symbolic rather than substantive. Representing affected citizens without charge, Crockett sought to challenge the insufficiency of that settlement and to secure genuine accountability. The corporation's defense team was led by William Bradford, a litigation veteran whose hourly fees reportedly exceeded $2,000. The stakes bordered on staggering not only financially, but structurally. The company's entire data-driven business model stood vulnerable. For consumers nationwide, this case represented perhaps the only realistic chance to affirm privacy as a protected right. For the tech industry, the ruling could reshape the legal boundaries governing data itself. For Judge Leon, The dispute raised profound constitutional questions, born from an era far preceding digital surveillance or algorithmic profiling. For Crockett, the matter was deeply personal. She had authored privacy legislation, and now sought to prove that such laws could in practice shield citizens from corporate power. The hearing concerned tech giants' motion to dismiss before trial. Should the motion prevail, millions would be left without any channel for redress. Should Crockett succeed, the corporation would face discovery, testimony, scrutiny, and potentially sweeping consequence. What the corporate team did not know was that Crockett had spent months constructing the legal architecture of her argument. She had studied case law stretching from early common law privacy doctrine to contemporary appellate divisions, identifying the precise fault lines where precedent could shift. The courtroom held its collective breath when Bradford began. "Your Honor," he stated with refined confidence, "this suit must be dismissed because plaintiffs cannot establish Article 3 standing. The Supreme Court has held repeatedly that statutory violations absent concrete injury cannot sustain federal jurisdiction." Judge Leon considered the assertion carefully, occasionally glancing at the briefs stacked before him. When Bradford concluded, the judge posed sharp follow-up questions, indicating genuine deliberation. "Mr. Bradford, you rely heavily on TransUnion. How do you address the plaintiff's contention that the category and volume of data here extend beyond what was considered in that case?" Bradford answered smoothly, "The data may differ in type, but the principle is unchanged. Plaintiffs must demonstrate tangible harm. They have not." Then Crockett approached the podium. The atmosphere shifted as though the entire room inhaled at once. She acknowledged the precedent cited, then pivoted. "Your Honor," she began, "while my colleague accurately references TransUnion, he omits a crucial point in Justice Kavanaugh's majority reasoning. On page 9, the decision explicitly recognizes intangible injuries as concrete, even absent visible consequences." Judge Leon lifted his brow. "Proceed, Congresswoman." "The court traced this recognition to Blackstone and common law traditions foundational to our Constitution," Crockett continued. "Unauthorized acquisition and distribution of private information has long been understood as a cognizable harm requiring remedy." Bradford stiffened. This historical approach had not been briefed. Leon leaned forward. "But how does this overcome the Ninth Circuit precedent counsel cited earlier?" Crockett answered without hesitation. "Your Honor, I am not urging the court to disregard precedent. I am stating that it does not govern this matter for 3 reasons. She raised one hand, index finger extended. "First, in the Ninth Circuit cases, data was collected but never transferred or shared. In this case, we possess documentary evidence of tech giants selling the data to 147 third-party entities." A second finger. "Second, those rulings predate Spokio as clarified by TransUnion. Justice Thomas expressly acknowledged that disclosure constitutes concrete harm." A third finger. "Third, a circuit split exists, noted in footnote 4 of TransUnion. The Third, Seventh, and Second Circuits recognize unauthorized dissemination as harm, whereas only the Ninth construes it narrowly." Bradford began flipping frantically through his copy of TransUnion. Leon's expression shifted, first in surprise, then in analytical interest. "Explain the circuit division in detail." Crockett proceeded, referencing Thompson v. Data Corp and similar cases recognizing injurious privacy breaches even where damage cannot be visibly quantified. And so the hearing evolved. What began as a routine procedural argument now resembled an advanced legal symposium. Students scribbled furiously. Even the judge's clerk seemed riveted. The courtroom's atmosphere had shifted dramatically. What had begun as a formal motion hearing now felt more like an intense legal seminar, with every observer leaning forward to absorb the nuances of Crockett's arguments. Judge Leon, previously skeptical, now listened intently, occasionally jotting notes while posing questions that demonstrated both curiosity and genuine engagement. The interplay between Crockett and Bradford had transformed the hearing into a high-stakes intellectual duel. Law students in the gallery scribbled furiously, recognizing the significance of each citation and legal distinction. Judge Leon leaned slightly forward, his pen poised, and asked Counselor, "If your theory of standing is accepted, how would it apply to cases where data is encrypted before transfer to third parties?" Crockett did not hesitate. "Your Honor," she replied, "this was directly addressed by the D.C. Circuit in Johnson for Medical Soft. The court there held that while technical safeguards may mitigate risk, they do not eliminate the harm of unauthorized transfers, particularly when the recipient maintains encryption keys, as occurred with 83 of tech giants' data transfers. In this case, a subtle shift passed over the judge's expression. He made a notation clearly impressed by her command of a relatively obscure case. Bradford sensed the momentum slipping. He attempted to regain control. "Your Honor," he began, "regardless of these technical distinctions, federal courts remain ill-equipped to address speculative claims. It is Congress's role to create new statutory remedies." Judge Leon's voice cut sharply across the courtroom. "Mr. Bradford, are you suggesting this court lacks authority to interpret existing statutes in light of evolving technologies? That seems inconsistent with your position in Data Stream before Judge Williams last year." The reference caught Bradford off guard. He hesitated, recalibrating. "Your Honor, the contexts were different." "Were they?" Leon asked. "In both cases, statutes written before current technology were at issue. Yet in Data Stream, you argued for expansive application favoring your client here for narrow interpretation. Is it principle or simply your client's interest?" The courtroom murmured. Judge Leon rarely highlighted inconsistencies so directly. Bradford flushed, searching for justification. Crockett seized the opening with professional poise. "Your Honor, the Supreme Court has long held that courts must adapt statutory frameworks and constitutional principles to emerging technologies. Justice Roberts and Carpenter, Far's United States emphasized that privacy protections must endure despite technological evolution. Statutory protections against private entities should be interpreted with the same fidelity to core principles." The gallery seemed to lean in collectively, sensing the potency of her argument. Even law clerks whispered to each other about how deftly she had dismantled Bradford's separation of powers argument. As the hearing neared 2 hours, far longer than the original 30-minute schedule, Judge Leon posed what would become the pivotal question. "Congresswoman Crockett, even if all you allege is true, the fundamental defense argument is that no concrete harm has occurred to justify federal intervention. What is your strongest response?" Silence fell. The courtroom was fully engaged. This question cut to the heart of the dispute, and the judge's tone indicated genuine openness to persuasion. Bradford leaned forward slightly, confident that a direct query would expose weaknesses in the plaintiff's position. Crockett paused, then delivered a response later cited in law reviews. "Your Honor," she began, her voice calm but resonant, "the concrete harm here is neither theoretical nor abstract. It is deeply rooted in both constitutional and common law traditions. The framers of the Bill of Rights intended privacy protections to extend beyond mere physical intrusions. Control over personal information is fundamental to liberty. The Fourth Amendment does not require tangible damage. It safeguards the intrusion itself." Judge Leon nodded subtly, clearly, following her reasoning. Crockett continued, her tone growing measured but assertive. "Common law recognized harms without consequential damages. Trespass, invasions of privacy, and publication of private facts were actionable on principle alone. Here, tech giant would have the court believe that absent financial loss or specific consequences, Americans have no recourse when intimate personal data is collected and sold to hundreds of third parties without consent." She reached into her briefcase and retrieved a sealed envelope. "With the court's permission, I submit a sealed exhibit demonstrating the concrete nature of the harm in this case." Judge Leon gestured to his clerk, who approached to receive the envelope. "What does this exhibit contain?" "Counselor," he asked. "It contains actual data tech giant collected and sold from 5 named plaintiffs." Crockett explained, "Not generalized metadata, specific medical searches, location tracking, voice recordings captured when the app was inactive, and encrypted private messages. The data was obtained through discovery in a related state, proceeding under a protective order, allowing its use in related litigation. It demonstrates real ongoing harm." Bradford jumped to object. "Your Honor, this material was not in the original complaint. Introducing new factual claims is improper during a motion to dismiss hearing." Judge Leon regarded him calmly. "A motion to dismiss requires the court to accept the plaintiff's factual allegations as true. If this evidence supports those allegations, its consideration is appropriate." "How was it obtained?" Crockett replied smoothly, reiterating the protective order and explaining its relevance. Leon paused briefly before nodding. "I'll review this in chambers. Continue with your argument, Counselor." Crockett pivoted back seamlessly. "Your Honor, The defense's position suggests that companies can collect and monetize Americans' most intimate details without meaningful consent, sell it broadly, and avoid accountability because the harm is deemed intangible. This is legally flawed and fundamentally undermines privacy rights central to our tradition since the founding. She gestured to the gallery. Consider the average American clicking. I agree on A46-page terms of service is not meaningful consent. Technical claims of anonymization are misleading. 80% of Americans can be uniquely identified with just 3 data points: zip code, birth date, and gender. A ripple moved through the courtroom. Reporters typed furiously, capturing her precise citations and arguments. Crockett presented internal emails from tech giant executives, acknowledging the insufficiency of anonymization claims. Bradford scribbled frantically, attempting to counter evidence he had not anticipated. She continued, "Concrete harm is threefold. First, violation of autonomy when personal data is taken without consent. Second, ongoing exposure as this data circulates among hundreds of entities. Third, risks arising from aggregation of sensitive data, from health information to financial vulnerabilities, creating exploitation potential." Judge Lane nodded attentively, noting each point. Bradford objected again, citing procedural issues, but Crockett responded confidently. Paragraph 78 of our complaint alleges targeted fraudulent communications. These declarations provide evidence supporting existing allegations, not new claims. Leon consulted the complaint, flipped to the page, and after a pause, nodded. "She is correct, Mr. Bradford. Objection overruled." Crockett pressed on. "Your Honor, statutes protecting privacy are not mere technical rules. Congress recognized that privacy violations cause real harm, even when difficult to quantify. The rights to control personal information have been violated, and courts must enforce them." Judge Lane posed another precise challenge. "Counselor, doesn't that risk eliminating standing requirements? If statutory violation alone creates standing, aren't we merging separate inquiries?" Crockett answered clearly. "Not at all. Your Honor, the Supreme Court requires that statutory rights bear close relation to harms traditionally recognized at common law. Here, intrusion upon seclusion, public disclosure of private facts, and appropriation of name or likeness are established common law harms. The statutes protect modern equivalents. The connection is direct and undeniable." The judge's demeanor had shifted from skeptical to engaged. A transformation court observers recognized immediately. The momentum had swung decisively. Crockett had reframed the discussion from procedural technicalities to substantive legal principles, illustrating how evolving technology intersects with foundational privacy protections. Crockett paused, scanning the courtroom, ensuring full attention. "There is one final point regarding concrete harm, Your Honor. Tech giant asserts Americans have no reasonable expectation of privacy unless they suffer specific consequences. This is fundamentally flawed. It ignores centuries of legal precedent recognizing the intrinsic value of privacy. In the digital age, systematic exploitation of personal data is a novel but real form of injury. Courts have historically adapted to new harms. Industrial pollution and broadcast defamation were recognized without prior precedent because harm had evolved. We now face a similar challenge with digital privacy." Her argument resonated across the courtroom. Every attendee, from law students to reporters, followed each meticulous point. Judge Lane's pen moved steadily, capturing both the substance and the significance of her statements. Crockett concluded, gathering her notes. "The question before this court is not merely standing or statutory interpretation. It is whether our legal system recognizes and protects privacy in an era where technology makes intrusion easier and profitable." "Thank you, Your Honor." A silence followed her conclusion. Even Bradford appeared momentarily speechless. Students whispered admiration. Reporters typed furiously and clerks nodded appreciatively. Judge Lane cleared his throat and acknowledged the argument with measured respect. "Thank you, Counselor," he said, signaling the gravity of her presentation. After Crockett concluded her argument, the courtroom remained in a rare, almost reverent silence. Every observer, from law students hunched over their notebooks to seasoned reporters typing, frantically recognized that what they had just witnessed was extraordinary. Even the junior associates at the defense table sat still, exchanging glances of disbelief. The usual hum of whispered conversations and the shuffle of papers was absent. The gallery was collectively absorbing the magnitude of her presentation. Judge Lane, seated at the bench, leaned back slightly, his expression contemplative. For the first time that morning, he allowed a faint smile to cross his features, a subtle acknowledgement of the intellectual rigor Crockett had brought to the case. Bradford rose to respond, his earlier confidence noticeably shaken. "Your Honor," he began. "Congresswoman Crockett's argument is undoubtedly thorough, but it still relies heavily on historical and theoretical perspectives. The Ninth Circuit and other circuits have established clear guidelines on standing, and these should not be disregarded lightly." His voice, though measured, betrayed a flicker of uncertainty. The gallery watched closely, aware that this was the moment where the defense's legal fortitude would be tested against Crockett's meticulous preparation. Judge Lane interjected immediately. "Mr. Bradford, I am very interested in how you reconcile your argument with the Second Circuit's Thompson decision, which Congresswoman Crockett cited extensively. This case seems directly analogous, particularly regarding the unauthorized dissemination of non-financial data." Bradford's hands tightened around the podium. He flipped rapidly through his notes, searching for references to Thompson that might bolster his position, but the thoroughness of Crockett's preparation was apparent. She'd anticipated this very confrontation. "Your Honor," Bradford continued, "the Thompson decision, while persuasive in certain aspects, is distinguishable. It concerns specific data categories and financial contexts that differ from the scope of tech giants' operations. Therefore, applying its principles here is not appropriate." Crockett's gaze never wavered from the judge. Calmly, she responded with respect. "Your Honor, the Second Circuit explicitly addressed non-financial data transfers. On page 27, Judge Sullivan clearly stated that the type of data is less relevant than the unauthorized transfer to third parties, which constitutes harm in itself. This aligns directly with the evidence in our case where sensitive personal information, medical, locational, and communications data was shared with hundreds of entities without consent." She allowed a brief pause, letting the words settle before continuing. "This is not theoretical harm. It is documented, ongoing, and significant." A murmur passed through the courtroom. Even some members of the gallery, who had arrived without a detailed understanding of privacy law, recognized the weight of her point. Judge Lane made a note, his pen moving swiftly, and then nodded toward Bradford. "Counsel, how does your interpretation account for this direct acknowledgement in Thompson?" Bradford hesitated. His previously confident demeanor wavered. "Your Honor, while the Second Circuit acknowledged those aspects, they were framed within a specific context of statutory construction that differs from our current consideration." Judge Lane's tone was deliberate cutting. "Is the principle different, Mr. Bradford, or merely the specifics? You argued expansively in data stream under analogous circumstances, yet here you seek the narrowest possible application. Are we interpreting law consistently or merely advancing a client's interest?" The courtroom fell silent again, the tension almost palpable. Bradford's eyes darted toward his associates, who were rifling through briefs and case notes, desperately seeking a foothold. Even the most junior clerk recognized that this line of questioning was extraordinary. Judge Lane was scrutinizing not just the argument, but the logic and consistency of the defense's approach. It was a clear indication that Crockett's strategy had shifted the momentum decisively. Crockett, sensing the critical opening, stepped forward slightly. "Your Honor, the Supreme Court has consistently held that when statutes encounter technological developments unforeseen by the framers, courts must adapt the application without violating foundational principles. The Carpenter decision illustrates this principle in the context of government surveillance. We are now applying similar logic to private entities. Statutory protections are intended to preserve rights in practice, not merely in theory. When companies collect, monetize, and distribute personal information without consent, a real and immediate harm exists that courts are obliged to recognize." Judge Lane nodded slowly, clearly engaged. His questions became less combative and more exploratory, probing the application of Crockett's framework to hypothetical scenarios. "Congresswoman, if data is anonymized but re-identifiable through aggregation, does your framework still recognize concrete harm?" "Absolutely, Your Honor," Crockett replied without hesitation. Tech giants' own internal documents confirm that supposedly anonymized data can be re-identified with minimal information points. In this case, their chief data officer admitted that anonymization claims were technically true, but practically meaningless. The aggregation of sensitive data locations, health information, private communications creates actionable harm even when direct financial consequences are absent. Courts must consider the substance, not just the form of privacy violations. The gallery reacted audibly this time. Reporters paused. Their typing students leaned forward, and even some spectators from the public benches whispered quietly to each other. Bradford scribbled notes furiously, attempting to anticipate the next line of argument, but Crockett had already anticipated each challenge. She turned toward Judge Leon, her voice steady but firm. Your Honor, let us consider three distinct forms of concrete harm. First, the violation of autonomy. The plaintiff's personal data was taken without meaningful consent. Second, ongoing exposure. This YAM data continues to circulate among hundreds of entities, each with varying security standards. Third, direct risk. The aggregation of sensitive information from health to financial data increases the potential for targeted exploitation, identity theft, and unauthorized surveillance. Each of these is recognized under common law as a concrete harm, rooted in centuries of jurisprudence. Bradford rose, objecting once more. Your Honor, these claims extend beyond the original complaint and rely on new factual material not previously submitted. Crockett remained composed. With respect, Your Honor, paragraph 78 of the complaint specifically alleges targeted fraudulent communications based on data collected by the defendant. The evidence we present merely substantiates existing allegations. No new claims are introduced, only supporting documentation. Judge Leon reviewed the complaint briefly, flipping pages carefully. After a moment, he spoke. Counsel, the objection is overruled. The complaint contains the allegations in question. The supporting evidence is appropriate for consideration. Crockett nodded, acknowledging the ruling, and continued building her argument. Your Honor, the statutory purpose must also guide interpretation. Congress intended privacy rights to protect against both tangible and intangible intrusions. A narrow interpretation that ignores these harms would contradict legislative intent and undermine centuries of legal precedent recognizing privacy as a fundamental interest. Courts historically adapt to new forms of harm, as seen in environmental law, defamation, and other evolving domains. Digital privacy is merely the latest frontier. Judge Leon's eyes were focused, pen in hand, capturing every nuance. He asked another pointed question. Counselor, doesn't this approach risk collapsing the standing requirement? If every statutory violation creates standing, where do we draw the line? Crockett smiled faintly, poised and confident. Not at all, Your Honor. Standing remains grounded in harm traditionally recognized at common law. The difference is that modern statutes codify protections against equivalent harms in contemporary contexts. Here, intrusion upon seclusion, disclosure of private facts, and appropriation of personal identity all have direct modern analogies. The connection is not speculative. It is direct, documented, and legally recognized. The courtroom was now fully engaged. Students scribbled furiously. Reporters typed rapidly, and the defense team appeared increasingly pressured. Judge Leon's questions shifted from challenging to analytical, exploring the practical application of Crockett's framework across hypothetical scenarios and varied technological contexts. It was a rare display of judicial engagement, signaling profound interest in the conceptual and practical implications of her argument. Crockett paused for a moment, ensuring her points resonated. Your Honor, one final consideration, she said, her voice unwavering. Tech giants' defense relies on a troubling assumption that privacy is only meaningful when measurable financial or tangible loss occurs. This contradicts both historical and constitutional principles. Privacy is intrinsically valuable. Unauthorized collection, sale, and dissemination of personal data constitute harm. Irrespective of additional consequences, courts have always evolved to recognize new forms of injury, and digital privacy is no exception. The gallery remained silent, fully absorbed. Even Bradford's junior associates, usually distracted, were now clearly engaged, quietly acknowledging the intellectual skill on display. Judge Leon made a series of notes, his demeanor reflecting respect and recognition. Crockett concluded, gathering her papers. The question before this court is whether our legal system will protect privacy in the digital age. Thank you, Your Honor. The courtroom remained quiet for several seconds. Bradford approached the podium visibly less confident than when the hearing began. His prepared rebuttal now seemed insufficient against Crockett's comprehensive and meticulously structured argument. He did. He attempted to respond, citing precedents and technical interpretations, but Judge Lyon's penetrating questions revealed that the momentum had shifted decisively toward the plaintiff. Each citation was met with precise inquiries about its applicability to the evidence Crockett had presented. Each technical argument faced probing questions that required real-time reconciliation with her framework. After Bradford's final attempt, Judge Lyon addressed both attorneys. "This has been one of the most substantive arguments I have heard in 20 years on the bench." He said, his tone both measured and warm. "I commend both counsel for their preparation. Congresswoman Crockett, your argument is exceptional, not only in clarity, but in its depth and precision. You have provided a framework for addressing digital privacy harms that warrant serious consideration." The courtroom reacted subtly. Students exchanged odd glances. Reporters furiously typed summaries, and the defense team absorbed the unusual judicial praise. Judge Lyon continued gathering his papers. "I will take this motion under advisement and issue a written opinion. The questions raised today strike at the heart of how our legal system adapts to technological change, and they merit more than cursory treatment. This court is adjourned." Ash exited. Whispers and animated discussions erupted in the gallery. Law students huddled in groups debating every legal point. Journalists rushed to capture quotes and impressions. At the plaintiff's table, Crockett's co-counsel grasped her hand. "Absolutely masterful," she whispered. Crockett allowed herself a small, satisfied smile. As the courtroom emptied, the energy in the hallways of the federal courthouse was electric. Reporters rushed to transmit their stories. Sketches of the hearing circulated immediately, and law students lingered in small groups, replaying the exchanges in their minds. Crockett collected her notes deliberately, aware that the hearing had already begun to make waves far beyond the room. Her performance had been more than just an argument. It was a statement about the adaptability and relevance of law in the modern digital era. By the time she reached the steps outside the courthouse, a small crowd of law students had gathered, waiting hesitantly. "Congresswoman Crockett," one of them called, "may we ask a few questions about your approach?" She paused, smiled warmly, and nodded. "Of course. The future of privacy law is in your hands. Let's discuss it." Cameras and smartphones captured snippets of the exchange, which immediately began circulating across social media and legal forums. Within hours, the legal community began dissecting every aspect of Crockett's argument. Law professors incorporated the hearing's transcript into class discussions, illustrating how historical common law principles could be applied to modern technology challenges. At Harvard, Yale, and Stanford, students debated her framing of concrete harm and its implications for future privacy litigation. Legal analysts on television described her argument as a paradigm shift, a rare instance where courtroom advocacy had the potential to redefine the landscape of digital rights in the United States. Inside her congressional office later that day, Crockett's staff briefed her on the immediate reactions. News outlets had highlighted Judge Lyon's visible transformation from skeptical dismissal to engaged attention, emphasizing the gravity of her reasoning. Internal memos from law firms noted that if Judge Lyon adopted Crockett's framework technology, companies could face unprecedented legal scrutiny, potentially reshaping the industry's approach to consumer data, even outside the legal and political spheres. Consumer advocacy groups began mobilizing, recognizing that her argument could serve as a blueprint for protecting citizens' rights in the digital age. The broader political implications were also becoming apparent. Analysts speculated about Crockett's national profile, recognizing that her expertise and performance might propel her to positions of greater influence, whether through higher office or judicial appointment. Commentators praised her rare dual perspective as a legislator and practicing attorney, noting that few individuals in Washington possessed her combination of practical courtroom experience and deep policy understanding. Social media buzzed with admiration, highlighting the precise articulation of legal doctrine and the compelling moral argument underpinning her case. Within weeks, the legal impact became concrete. Judge Lyon issued a detailed 87-page opinion denying tech giants' motion to dismiss. The ruling extensively referenced Crockett's argument adopting her framework for understanding concrete harm in the context of unauthorized data collection. He wrote that unauthorized dissemination of personal information constituted real and actionable harm, grounded in constitutional tradition and common law principles. Legal scholars hailed this decision as transformative, potentially the most significant privacy ruling since Carpenter versus United States. Tech giants' leadership, realizing the potential repercussions, began internal deliberations on the future of their litigation strategy. Their stock experienced a noticeable drop, reflecting investor concerns about financial exposure and business model viability. Other major technology companies quietly initiated reviews of their data practices, some engaging outside counsel to assess compliance and risk under the evolving legal framework. Privacy advocacy organizations publicly lauded the ruling, seeing it as a critical step toward meaningful enforcement of digital privacy rights. The ruling quickly influenced other courts. Within 6 weeks, a federal judge in California cited Judge Lane's opinion in rejecting a similar motion to dismiss against another technology company. In the following months, additional district courts referenced the decision, creating a growing consensus around Crockett's framework. Law schools reported an unprecedented surge in interest in privacy law courses, while professional organizations organized seminars and conferences exploring the implications of the ruling. Crockett herself was inundated with invitations to speak at conferences, universities, and policy forums. She delivered keynote addresses emphasizing the importance of safeguarding privacy in an era of rapid technological change. Her speeches often reflected the same clarity and rigor she demonstrated in court, outlining historical precedents, constitutional foundations, and practical implications for citizens' rights. Her dual role as legislator and attorney allowed her to translate complex legal principles into tangible policy recommendations and educational insights. Months after the hearing, polling indicated that the public's awareness of digital privacy issues had grown substantially. Citizens expressed greater concern about personal data collection and a desire for stronger legal protections. This shift influenced policymakers at various levels, prompting discussions about legislative reforms that could complement judicial enforcement. The hearing and Crockett's argument in particular had catalyzed a broader national conversation about privacy technology and accountability. Tech giant eventually pursued settlement negotiations. Recognizing the risk of full discovery and trial under the new legal framework, executives agreed to a comprehensive settlement. They consented to pay $1.28 to $8 billion in damages to affected users, implement stringent new privacy protections, delete previously collected data, and submit to independent monitoring for a period of 5 years. The settlement represented one of the largest and most comprehensive privacy agreements in history, setting a precedent that reverberated across the industry. At the press conference announcing the settlement, Crockett stood with the lead plaintiffs, ordinary Americans whose private information had been exploited. "This outcome is not merely about compensation," she stated. "It affirms the principle that privacy remains a fundamental right in the digital age, deserving of meaningful protection. This is a victory, not just for the individuals represented, but for the integrity of the legal system and the broader societal expectation of equality." Media coverage highlighted her role as central to achieving this result, solidifying her reputation as a formidable advocate for civil liberties and digital rights. The implications for the legal profession were profound. Law firms adjusted strategies, recognizing the need to assess privacy risks proactively and implement practices consistent with emerging judicial interpretations. Legal scholars continued to study the transcripts of Crockett's argument as a model of advocacy, emphasizing the seamless integration of historical knowledge, constitutional analysis, and practical evidence. Her approach was widely described as a masterclass in demonstrating both intellectual rigor and persuasive communication, bridging technical legal reasoning with moral and societal imperatives. 1 year after the hearing, the effects of the case were evident across the technology sector. Multiple companies updated privacy policies, clarified consent mechanisms, and adopted new standards for data handling. Industry associations established privacy by design guidelines inspired by the principles articulated in Crockett's argument. Consumers became more aware and assertive regarding the use of their personal data, emboldened by the legal precedent affirming their rights. In academia, the case became a cornerstone of privacy law education. Harvard Law Review dedicated a special issue, analyzing the Crockett framework, exploring its application to emerging technologies from social media to AI systems. Georgetown University established an annual lecture series in her honor, focusing on the intersection of technology, civil liberties, and law. Leading legal scholars praised the case as a watershed moment in modern jurisprudence, noting that it had elevated public understanding of privacy beyond technical jargon into the realm of fundamental rights. 2 years later, as Crockett prepared for a fourth term in Congress, she received an unexpected call from the White House. The president was considering her nomination to the D.C. Circuit Court of Appeals, the V court that would have heard tech giants appeal had the settlement not occurred. Crockett reflected thoughtfully on the conversation, noting that her career had always been guided by a commitment to ensuring the law served justice for ordinary citizens. Whether in Congress, in courtrooms, or potentially on the appellate bench, her focus remained on advancing fundamental rights in a changing technological landscape. The legacy of her confrontation with tech giant extended far beyond the immediate legal outcome. It fundamentally reshaped public perception of digital privacy, set influential precedents for data protection, and inspired a generation of young attorneys to view privacy advocacy as an essential frontier for civil rights for everyday Americans. The case underscored that their personal information could not be exploited, without recourse, affirming that certain rights remain fundamental even amidst technological evolution. Crockett's argument became a touchstone for legal, education policy discussions and public awareness campaigns across the country. Law students studied the nuances of her reasoning. Legislators consulted her insights on emerging privacy legislation, and privacy advocates cited her framework as a benchmark for best practices. The ripple effects of her courtroom performance were tangible, influencing law policy, business practices, and societal expectations. Even as the legal battles surrounding tech giant continued through ancillary proceedings and compliance oversight, Crockett's performance in front of Judge Lyon remained the defining moment. It demonstrated the profound impact of preparation, historical insight, and precise advocacy. By framing modern privacy harms within a long-standing legal tradition, she bridged centuries of jurisprudence with contemporary challenges, offering a blueprint for how courts, lawmakers, and citizens could confront the complexities of a digital society. As she walked through the halls of Congress reflecting on the past year, Crockett recognized that the case had transcended her role as a representative or attorney. It had become a statement about the enduring importance of legal principles, the adaptability of the justice system, and the moral imperative to protect fundamental rights against evolving threats. The hearing, the ruling, and the subsequent settlement collectively represented a milestone in the ongoing struggle to balance technological innovation with personal privacy, ensuring that in an era of unprecedented data access, human dignity and autonomy remained safeguarded. For the broader public, the case illuminated the tangible realities of privacy in everyday life. Ordinary citizens, now more informed and empowered, understood that consent, transparency, and accountability were not mere abstract concepts. They were enforceable rights grounded in both law and history. Crockett's advocacy transformed the dialogue around privacy from abstract legal discussion into a relatable, actionable principle that resonated across society, signaling that justice could evolve alongside technology, rather than lag behind it. By the end of the second year, the Crockett framework was firmly embedded in American legal consciousness. Courts, corporations, educators, and the public recognized the enduring significance of her work. What began as a high-stakes courtroom battle had grown into a broader movement, reshaping the landscape of digital privacy and redefining the standards for protecting fundamental rights in a technologically advanced society. Crockett's argument, preserved in transcripts, case law, and academic analysis, would continue to serve as a guidepost for advocates and jurists confronting the challenges of the digital age, ensuring that privacy remained a protected, enforceable, and respected right for generations to come.